I can't tell you the number of people who told me that one. Good morning, Your Honor. Daryl Barton appearing on behalf of the Lewises,
All right.
who are both present in the court today.
Yes. And Ms. Loudon is not present, and I'd informed or sent a message down to the courtroom that I wouldn't call this until 10 o'clock, giving her time to get here. My staff did remind me that at the last hearing, I believe on May 28th, she was also not here, and we adjourned it because she said that she thought it was at 11 instead of 9. We adjourned it out so that everybody wasn't held. There was a confirmation from her when we gave her the new time of the 9 o'clock. She confirmed that it was 9 o'clock and she is not here. The only thing I did not check, can we just run down to courtroom C and just make sure she's not here? I should have done that on my way out. I apologize.
That's all right. We'll wait.
Did Miss Barton say wait? In all the years, that's probably the first time ever.
What did
You're
just say?
usually I said you'll wait. And I'm thinking that's got to be the first time ever that you have said that to me. It's like her case doesn't get called first. She's like all over me.
Last time you're going to check my ID too. At least you're not telling me I'm not who I am.
That's true.
The removal has been received and should be.
I do see that. No. All right. Had my so the record's clear. I had the bailiff, Mr. Allen, go check to make sure that she was not down in courtroom C. She has failed to appear. Would you like to take a default on this case?
Yes, Your Honor.
All right. Do you solemnly swear from testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Go ahead.
According to the information provided by my client, the amount outstanding that was originally asked for was $9,200 plus cost plus the statutory interest that has accrued since the original judgment.
All right. The 92 plus cost. The defendant the defendant having failed to appear, judgment will enter in the amount prayed for of $9,200 plus could be applicable cost and attorney fees and interest.
Did the case number change now that it's general civil, Your Honor?
I think the only thing that happens is a GC is added. Is that just a G?
Okay.
Okay. Just a G will be added to that.
And we'll
So-
prepare a judgment for that amount
And I will
Submit it.
sign it upon its presentation to the court.
okay, I have another question, and that is, we also, come on. We'd also plan to submit a request in order to seize property with the judgment involved, if that, and ask that you sign it also when it's submitted.
I believe with the default, I have to wait the 21-day period.
That's right. So after the 21.
After the 21 days,
Days.
when that's submitted, then
I don't
yes.
want to have to come back. Your Honor.
Any post-judgment remedies you can submit, then the court will sign off. And
Thank you. That's what and just to be clarified, they have a security deposit, which they've not touched through this whole thing. They want to be able to immediately use it.
let's do it this way. How much was the security?
It was $1,100.
1,100. Was any of the 9,200 rent or utilities?
Yes. Football, 3,200 was the water bill.
Okay.
About $3,000 in rent.
Okay, then under the Security Deposit Act, they could use that
For
to cover
utilities.
for rent and utilities. So
Landlord
it's
tenant
not for damages. Just make sure that it's
Yeah. For utilities.
separated in that fashion. Yes,
I love it. Landlord Tenant Relationships Act.
yes. All right.
Thank you, Your Honor.
Thank you. Yes, ma'am.
We enjoyed seeing you on the national news.
Oh, I can't tell you the number of people who told me that one.
You and a lot of other people, and I guess I will thank you for that. All right.
What begins as a routine civil hearing quickly turns into a decisive legal moment, not because of heated arguments or dramatic testimony, but because one person simply didn't show up. As the case is called, the plaintiff's attorney confirms that his clients are present and ready to proceed. But the defendant is missing. The judge immediately recognizes a troubling pattern. This isn't the first time she has failed to appear. In a previous hearing, the case had already been delayed because she claimed she got the time wrong. The court had shown patience, rescheduling the matter and clearly confirming the correct time to 9 a.m., and yet, despite that second chance, she is absent again. Still, the judge doesn't rush to judgment. In a careful and methodical step, court staff are asked to check nearby courtrooms to ensure she hasn't mistakenly appeared elsewhere. It's a small but important act, reinforcing that the court is committed to fairness, even when one side is not present, but the result is clear. She is nowhere in the building. At that moment, the tone shifts from flexibility to finality. The judge formally declares that the defendant has failed to appear, and the plaintiffs are given the opportunity to move forward without her. They request a default judgment, a legal ruling granted. When one party fails to defend their case, the court proceeds under oath. The plaintiff's attorney presents the financial details. The original claim totals $9,200, along with additional court costs, attorney fees, and statutory interest that has accumulated over time, with no opposition and no defense. The judge accepts the claim. A default judgment is officially entered for the full amount requested. A decisive outcome, driven entirely by the defendant's absence, but the hearing doesn't end there. The discussion shifts toward what comes next. Enforcement. The plaintiffs plan to pursue collection by requesting court approval to seize property if necessary. However, the judge explains an important legal safeguard. They must wait 21 days before taking further action. This waiting period ensures due process, allowing a final window for any post-judgment motions. Once that period passes, the court confirms it will approve the necessary enforcement orders without requiring another hearing. Then comes another key issue, the security deposit. The plaintiffs reveal that they have been holding a deposit of $1,000, which they have not yet used during the dispute. They ask whether they can immediately apply it toward the outstanding amount. The judge carefully considers this under landlord-tenant law. He clarifies that portions of the claim, specifically unpaid rent and utility bills, are eligible to be offset using the security deposit. In this case, a significant portion of the debt includes utility charges, such as a water bill. The judge allows it, but with a condition. The funds must be properly allocated and documented, specifically applied to rent and utilities in compliance with the law. This ensures transparency and prevents misuse of the deposit. It's a small but critical detail, showing how even in a one-sided case, the court maintains strict legal standards. As the hearing concludes, the atmosphere is calm but decisive. There was no dramatic confrontation, no emotional testimony, no legal battle in the traditional sense. Instead, the outcome was shaped entirely by absence. By failing to appear, not once, but twice, the defendant effectively gave up her chance to be heard. And in a courtroom, silence can be just as powerful as any argument. The judge's final instructions ensure that the plaintiffs can move forward efficiently, while still respecting procedural safeguards. In the end, this case serves as a powerful reminder. In the legal system, showing up is not just important, it's everything, because sometimes the difference between winning and losing is simply being there.